Welcome to part 2 of March 2023 Professional Ethics, where we are going to tackle question 4, 5, and 6. Part 1 is uploaded. Watch it. Yeah, so if you want to pass Professional Ethics, you need to look at purchase the question and answers at the website, which are 600 year 2008 to 2019 question and answers, 500 June 2021, 100. I have done videos part 1 and 2 for November 2021, April 2022, October 2022, March 2023 part 1. Now we are in part 2. If you want generally to pass Professional Ethics, you need first of all to read the Legal Education Act and Kenya School of Law Act on its regulations. 10% of the question will come from there, as I always say. Then 80% of the questions come from practice and ethical issues. You need to know the Advocate Acts, SOPEC, the Code of Conduct for Lawyers, 2017, Advocates Regulations, international instruments like UN Basic Principles for Lawyers, LSK Act and its regulations. Then the final part of 10% will come from the questions when advocate join other professionals, not an advocate in private practice. When he becomes a judge, a prosecutor, join county government, state councils, working in the office of ODPP. So you need to know the various statutes that govern those public officers, state officers, the regulations under those acts, code of conduct for those public officers and state officers, and they are good to go. So professional ethics is the most fair subject for 2 years in a row, 2023 and 2024. That's why we are doing this. So look at, purchase the question and answer, look at the video sequentially. So Father, we come before you as I do this recording. Be with me. Give me wisdom to dispense knowledge. Let the gadget that I'm using, the internet, the laptop, to work well. Let the people who are going to watch these videos be helpful to them as they prepare for the exams this day of the 13th March 2025. I pray all this believing Jesus Christ, my Lord and Savior. Amen. Yeah. So we go to the business of the day. So I'm going to read the question. This question was not also, as I said in part 1, the answers for March 2023 were released through the best performing students by CLE. So we are going to look at them, build on them, critique them. But there were no answers for November 2023, April 2024, and November 2024. And also it's good to say that this question 4 was the question that the best performing student omitted. Because in any exams, you are supposed to omit, not to do one question. So you do 5. So this is a question he or she did not do. I read the question. Prime Confectioners Limited is a manufacturer of new type of. So in an exam scenario, you underline the most important facts of the question. As now you look at ethical issues, practice issues. Yeah. So you underline potential statements in the questions, even before you read the question, that can potential questions can come from there. Yeah. So question 4, Pine Confectioners Limited is a manufacturer of a new type of chocolate under the brand name Daisy, in quotes, and the company was a client of Bantu Associates some 5 years ago. In one of the suits, Prime Confectioners had sued for trademark infringement in respect to biscuit products. The marketing manager of Prime Level had acknowledged to Oscar Kelly, a then partner of Bantu Associates Advocate, who was ordering the case. They initially adopted a product name significantly similar to a popular brand name in order to achieve market entry success. Oscar Kelly resigned from the partnership of Bantu Associates Advocate a year ago when the matter had already been concluded. Uh-huh. Unique Confections Limited is a manufacturer of highly popular that the brand names Delice and Delatio are significantly phonetically similar to confuse consumers that the two distinct brands of chocolate are the same, or that they are from the same manufacturer. Further, it is the view that price confusion is deliberately infringing on the popular Delisco trademark in order to achieve market benefit. Consequently, Onikose has approached Mwenemesi, a partner in the firm of Bantu Associates, to issue a trademark infringement suit against Prime Confections in court. So the question is asking A, discuss 5 professional ethics issues that when Messi has to consider and act upon before accepting to state legal proceeding against Spring Confectioners Limited. So you must separate this question. This company 5 years ago, Prime Confectioners, sued for trademark. Yeah. Through Bantu. But the case was successful, was concluded 1 year ago. And they were doing it through Oscar Kelly. Now, Unique Confessors now have instructed the same law firm through another advocate, Mwenemesi, a partner in Bantu Associates, to sue now Prime Confectioners on infringement of a trademark. So, this law firm 5 years ago was instructed 5 years ago, case concluded last year. The firm was instructed through Oscar Kelly to sue. Now they are being they were the plaintiff. Now, but that Oscar Kelly resigned and went. But the law firm still has the file, has everything in the file. Now, Unique Confessions, I want to sue again them. So, Prime Confessioners, they want to sue Prime Confessioners on trademark, what they had sued 5 years ago to the same law firm. So yeah, that is the interpretation of the question. So discuss five professional ethics issues that Mwanamesi has to consider to act before accepting institute legal proceedings against Prime. Yeah. So can the law firm institute proceedings against Prime, which they had acted for them 5 years ago, on trademark infringement, which they had acted for them as a plaintiff? So that is interpretation. So what is the answer? The answer the question is testing a candidate on conflict of interest and confidentiality. This question we tackled it at question 6B, October 2022. It was asking almost the same thing, where question 6B, October 2022, where someone had acted for a bank and now he has been instructed to sue the same bank. Yeah, you look at that question. So this is a repeated question. So what are the 5 professional ethical issues Mwanamesi is to consider? So the keyword is discuss 5 ethical issues. So you give 5 points. Consider before acting. Number 1, duty of confidentiality. So you say Section 134 Evidence Act prohibits advocates from disclosing any communication made by them and their clients during the course of their professional employment. So by acting for them, would Mwanamesi have to disclose confidential information that they had acted for this for the would-be defendant, prime confessioners, and the information that they received then? That is point number 1. Number 2, conflict of interest. Here you have discussed conflict of interest in the past in SOPEC, Rule 9 of public rules, of advocate practice rules, prohibits advocates from representing clients in a situation where there is a conflict of interest. So will there be conflict of interest is the second consideration. Point number 3, consent. So if there is a potential conflict of interest, the advocates must obtain express consent from the former client before representing the new client. So Mwanamesi need to consider getting consent from prime confessioners before representing the new client unique conventions. Point number 4, time factor. He needs to consider time factor. The 5-year mention may be relevant, but mere passage of time does not automatically clear potential conflict. So they were instructed 5 years ago, but the case concluded last year, 1 year ago. The relationship between the two matters, the nature of information disclosed in area matter, and the current representation or critical factors. Even if 5 years have passed, the law firm must evaluate whether issues are so connected that there is still a risk of conflict of interest. That is point number 4. Point number 5, Mwanamesi need to consider case laws and LSK ethical guidance on these matters. What are the case law on this? How has the case decided such kind of matters? So in some cases, the court have disqualified firms from representing clients where there was a risk of privileged information or where there was appearance of conflict. So those are the 5 ethical considerations he needs to consider. And you get your 5 marks. Yeah. Next question B. Concerned with the continued erosion of professional ethics by advocates in Kenya, you have decided to write a commentary on the issue to be published in Business Daily newspaper. And in commentary, you have proposed the view that professional ethics are indispensable necessity in practice of law. Highlight the justification that you emulate in support of the proposition. Yeah, so the keywords here are professional ethics are indispensable necessity in practice of law. So why is that? You give 5 points. The question has never been tested since 2008. So point number 1, upholding rule of law and justice. So professional ethics serves as a foundation of upholding rule of law, ensuring that legal practitioners act in a manner that respects the legal framework and principles of justice. Advocates have a duty to promote fairness, transparency, and impartiality in their actions without a strong adherence in the ethical standards. Lawyers may become agents of injustice, manipulating legal procedures for personal gain or to the detriment of others. Point number 2, public trust and confidence in the legal systems. So, you explain a lawyer's primary responsibility, the integrity of legal profession is directly tied to public confidence in the justice system. When lawyers engage in unethical practices such as dishonesty, corruption, and conflict of interest, they erode public trust. Trust is essential in maintaining the legitimacy of the legal profession. If the public believes that lawyers are motivated by self-interest and justice, the foundation of the legal system is compromised. Point number 3, protection of clients' rights as interest. A lawyer's primary responsibility is to protect the rights and interests of their clients while adhering to ethical guidelines to promote fairness and equality. Unethical behavior such as breaching confidentiality or providing misleading legal advice undermine the trust clients place in their lawyers. Professional ethics ensure that advocates maintain a client-centered approach, preserving the sanity of the advocate-client relationships, which is built on trust and mutual respect. Point number 4, promoting accountability and discipline within the profession. You explain, adherence to professional ethics create an environment of accountability and discipline within the legal profession. Ethical standards help regulate conduct of lawyers, setting clear boundaries on acceptable behavior. When unethical conduct is unchecked, it can lead to culture of impunity where individuals exploit their position of power for personal gain. Conversely, a robust system of professional ethics holds lawyers accountable for their actions and maintain the reputation of the profession. Point number 5, global and local professional standards. Legal practice in Kenya is increasingly attractive with global standards and international organizations such as International Bar Association (IBA) emphasize the importance of ethical conduct of lawyers worldwide. Adopting these principles ensures that Kenyan lawyers are not only adhering to local rules and guidelines, but are also aligned with the best global practices. This alignment ensures Kenya standing in the international legal community and fosters a competitive and ethically sound environment for legal practitioners. Yeah. So those are 5 points. You get 5 marks. Uh-huh. You go to the next question. Question 5. In preparation 2024 Royal Society of Kenya Annual Conference, you have been selected by the Committee on Continuing Professional Development to prepare a concept paper to be presented to the Young Lawyers Induction Session. The paper is required to highlight the legal entrepreneurship and self-advertising. From your lessons on professional ethics and practice classes, explain the 3 requirements to be met before setting up own legal practice in Kenya. So 3 requirements to be met before setting up own legal practice in Kenya, 3 marks. So this question is repeated in question 2, October 2022. You can look at it. When you see a question is repeated directly from the past paper, from the previous past paper, it usually tells you that the student did not do it well. They failed. That's why it's repeated in succession. Yeah. Yeah. So questions are usually repeated. That's why we look at these past papers. Uh-huh. So the answer is in year 2008 to 2019 Q&A. You can look at the answer of the best performing student, what he said, what he or she said. Before I add, so this question 5, he got 9 marks. He did well. Let's see what he said, he or she said. So, yeah, I'm projecting the answer for an advocate to be allowed to set a legal practice in Kenya. So be admitted as an advocate. Only persons admitted as an advocate of High Court of Kenya are allowed to set up legal practice. So he explained that. Point number 2, your name must be in the roll. So number 1 and 2 was speaking at the same thing. So he ought to have been given 1 point. Going to school, section 12, for being admitted as an advocate and your name in the row, that is 1 point. Then his point number 2, having a valid current practice certificate you knew every year. So he was given 3 out of 3, which to me I could have awarded him 2 out of 3 because being admitted as an advocate and your name being in the roll is just the same thing. So what are the other things? Apart from being admitted to the an advocate as an advocate, and you look at the section that talks about that in the Advocates Act, and having a practice certificate. We tackled this question in October 2022. You can look at the video substantively. As other thing is indemnity rules, having an indemnity, open a client account, and account advocate account rules, registering the business either as a business name, sole proprietaries, or a partnership, general partnership, or LLP. So must be registered as a business registration service. Having a tax KRA PIN certificate to pay taxes. Remember, a law firm must pay taxes, income tax, VAT, and such kind of things. Yeah, so that question we tackled it under question 2A, October 2022. And this is a repeated question. So B, explain 3 items expressly or impliedly prohibited by advocate marketing rules. That is B now. Five B, explain 3 items expressly or impliedly prohibit advocate marketing advertisement rules. 3 marks. Again, the question is repeated. You can look at question 3C, April 2022. It was asking the same thing in maybe in a different language. It's good sometimes to look at this question. So what was the question? So answer is in year 2008 to 2019 Q&A, page 142 to 146. So look here, the answers of the best performing student. What are the prohibited? Some action touting. Explain what touting is. Then he talked about under Rule 2, advocates are prohibited from advertising their services. But he did not talk about which kind of an advertisement. So number 3 is also talked about some advocates the view remaining obtaining a new client have engaged in undercutting. Yeah. So this question we are not very strong, except question 1, but he was awarded 3.3 marks. Yeah. So what were the best answers? Remember, the question is specific on advocate and advertisement rules. So because the question is telling us to confine ourselves on advocate and marketing rules, advocate marketing rules 2014, number 1, rule 5, should not be contained in advertisement. The name and identity of client, that is point number 1. The picture of the advocate's partner or partners, advocate employed in advocate's firm, academic or professional position held by advocates before advocate's admission to the role, a promise by an advocate to achieve a particular outcome. Yeah. Prohibited, also rule 7.2, prohibited forms of advertisement include radio, television, illuminated billboard or placards. Another one, rule 10, appearance in a conference, seminar, or similar public activity for advertisement. So that was the answers. The best performing student was favored there. He ought not to have gotten 3 out of 3. Because the question was confining yourself on advocates, marketing, and advertisement rules. 2014. Question C. So your best friend who is new to the bar wants to venture into an online business totally divorced from his legal occupation. Explain to him 4 ethical considerations that must be satisfied to him to keep out of trouble with the Royal Society of Kenya. So he wants to venture to online business, totally divorced from legal occupation. But remember, still he's an advocate. So what are the things? So, yeah, this question again is related to question 6 October 2022. You can look at it. So it was advocate and social media. So you give 4 points. You look at the answer of the best performing student. Page 25 to 26 of the booklet. So point number 1. So advocate must conduct themselves in a conduct befitting the status of an advocate. You should avoid confrontation, argument, and engagement while being an advocate. So advocates should not also publish matters that are ongoing in the court, online or to the public, as will amount to contempt of court. That is point number 2. Yeah, so advocate must keep clients' accounts separately from their personal account. So this online business he is doing, Mass is it does not mix his money. That money on online business and grant money. So he was awarded 3 out of 4. So what are other points to support this answer? You look at SOPEC 135 to 139, which we went through it in question 6A, October 2022. I don't need to belabor the point. You can look at SOPEC 135 to 139 and also the October 2022 part 2 video, which has question 6A. So question 5, the whole of it was repeated from the past papers. So that is a question someone needed to score maximum marks. And the best performing student did not disappoint. He got 9 out of 10. Look at SOPEC. You apply to it in every question, in almost all the questions. So read and understand it. Make your own notes. You may not remember the specific rule, but generally understand what it says. Don't quote a rule number if you don't know it. It's better you state generally. Even the section of the law, you must quote directly if you know the law, even a case law. Yeah. So we go to the last question of the day. Question 6, which I'm projecting in the screen, on the screen. And I'm going to read it. Conde is an associate in a firm of comma associate advocate as a side hustle. Also operates a bar that includes a disco at Kilimani, in addition to being the proprietor of a big electronic shop in Gong Town. The bar and the restaurant were recently focus of discussion in mainstream and social media due to excessive noise pollution at 2 hours of the night. So you are trying side hustle. Can an advocate? Remember, you have not read the questions, but you are on back of your mind. You are thinking about ethical practice issue. So operates a bar that includes Kilimani. So he operates a bar, you are the line, and a big electronic shop in Gone. He's involved in operation of bar and accounts. He's not involved in operation of the bar and electronic, as his employs sufficient staff in both establishments. Conde acted for the purchaser in Converse's transaction involving purchase of the half an acre land located in Kiambu Road for 550 million. The purchaser had only 40 million. He applied for a loan at United Credit Bank to cover the deficit, but there was a delay in processing and dispersing the money. Conde concerned that the day making payments by the purchaser would result in a property issued to other party, it concept that he would lose a hefty bonus he was entitled upon settlement of legal fees by the purchaser. Hefty bonus, you are the line. Consequently, Conde convinced the purchaser to pay the vendor 40,000 for purchase of power before the adjustment by deficit by the bank. He then wrote to the vendor's advocate stating that their firm would facilitate the payment of the balance of 10 million. As such, the vendor should execute the transfer documents. The vendor proceeded to execute the transfer document which Conde primarily wrote in the register for registration of transfer. 2 weeks later, the bank informed the purchaser that a further variation of financial status indicated the maximum that could be advanced to him was 5 million. The money was deposited in purchaser's account, who in turn transferred the cash to the vendor's advocate. The purchaser was unable to care for the 5 million balance. Consequently, the vendor's advocate issued a formal demand to the firm of Como and Associates to immediately make payments. Conde wrote a response on behalf of the firm of Como Associates, citing the principles of frustration and possibility of performance in respect to purchasers immediately to complete the purchase balance of the purchase price, and stated that the transfer of the property would be stopped. Based on the above facts, evaluate whether the above actions by Conde constitute a professional undertake and provide a justification for your answer. B. Discuss strategies that Conde can utilize to avoid liability in context of professional undertaking in both conveyancing and litigation matters. Explain 3 ways in which advocate disputed will punish an errant advocate. So you must read the 3 questions to see the differentiation in their asking, so that you provide different kind of answers. Yeah. So question A, evaluate whether the above actions by Conde constitute a professional undertaking and provide justification of the answer. So you give 3 points. Yeah. So it has 2 points. Is it a professional undertaking, and your justification? And it must be 3 points. That's how you answer these questions. So the question of professional undertakings usually come in conveyancing. Now in also comes in professional ethics, not many times. Last tested was question 5 July 2021. You can look at the way it was tested. Look at year 2008 to 2019 question and answers, page 185 to 188. You see how other professional ethics questions have been asked, to see how different types of questions have been asked and their answers. And now look at the answer of the best performing student. The best performing student did the question. He got 9 marks again. So the question has two parts. Whether it's a professional undertaking, so you must define what's a professional undertaking and give a justification why you are saying it's a professional undertaking. So a professional undertaking is a promise made and advocated. So it's an equivocal promise. That is a word you use, made by an advocate in the professional capacity. A professional undertaking being a promise intended to facilitate transaction where it would be impossible. So yeah. So that definition. So Conde's action amount to characterize an undertaking where he wrote to the vendor's advocate stating that his firm would facilitate the payment of balance of 10,000, and in placing Yeah, and impressing reliance to that reliance to that the vendors executed transfer. So that is point number 2. So in unequivocal promise done by an advocate to make the transaction go through, and based on that, the vendor's advocate executed and transfer. So it is a professional undertaking. Yeah. So when you do that, you get your 3 points. So to get 3 marks, you must explain what a professional undertaking is in details and why now you see that is why you see that it applies. Yes. Yeah. You get your 3 marks. Question B. So discuss the strategies that conduct can utilize in order to avoid liability in context of professional undertaking in both conversing and litigation matters. Mm-hmm. So that question is how many marks? 4 marks. So you give 4 points. You explain them. I'm looking at the answer of best performing student. This question has never been tested. This part B. So number 1, started the concord utilized expresses that the letter drafted is not an undertaking. By exceptionally providing in the letter that the letter is not intended to act as an undertaking, this will means that the letter is just an opinion and places no obligation on him. That is point number 1. So number 2, by ensuring the remaining monies are paid to by the purchaser. So the best thing you do for him to ensure that he keeps the promise and making up the purchaser pay the remaining amount. Explain that. Point number 3, he can expressly say that he is not held liable for failure of payment of the remaining amount of money. That was point number 3. He explained. He got 3 out of 4. So point number 4 is that engaging in alternative dispute resolution. So he can bring together the vendor and the purchaser on the table to avoid litigation on this matter for amicable solution to the matter. Remember, that's why advocates are called counsels. Yeah. You get your 4 points. Final question of the day. Question 6C. Explain 3 ways in which so 6B, you can look at the answer of best performing student and then on ADR. So 6B, explain 3 ways in which advocate disciplinary tribunal may punish an errant advocate. This is a question almost tested in every exams. I don't want to belabor. You discuss Section 64 of the Advocates Act, last tested in question 1C, October 2022. So there are 5 ways there how an advocate can be punished, and we have discussed in our previous videos. You can also look at the answer of best performing student. He got 3 out of 3. Yeah. So we have come to the end of March 2023, part 2. Subscribe to this channel. That is the only way you can support me. Tell your friends who are doing the exams. And see you in the next video, November 2023, part 1. God bless you. And may you pass your exams.